Hey everyone, it's Sam Bryant from Bryant Taylor Law, and today we're getting into what is the difference between bylaws and shareholders agreements. Before we get into it, Bryant Taylor Law is a business law firm that helps entrepreneurs start businesses and also helps business partners resolve their partnership disputes. So, what is the difference between bylaws and a shareholders agreement? The main difference is one is mandatory to have, and the other is optional. So, bylaws are mandatory. When you form your corporation, you must set out your directors and your officers, and you also must have bylaws. You don't file bylaws with the state. You do keep them internally, but you still must have them to be as part of the requirements for a corporation. Shareholders agreements are optional, but it doesn't mean that you shouldn't have one. I highly encourage every corporation to have shareholders agreements because a shareholders agreement is essentially a contract between the shareholders and the company. So the shareholders agreement is going to list out the rights that you have as a shareholder of the corporation. So when you become a shareholder and closely held companies, you're exchanging money or services for the stock, and with that stock comes certain rights that um, typically become the center of lawsuits if there's ever an issue between the shareholders and the company. So if you don't have that, those issues become very problematic if you ever have to go to court because there's no written evidence of what is supposed to happen or what you are supposed to be entitled to. For example, if the company is sold, what rights do you have as a minority shareholder if you want to leave the company or if you want to stay with the company and the absorbing company fires you, or not fires you, but you lose your shares. So a shareholders agreement will address issues like that. A bylaw is like a corporate manual. It's how the organization is going to be run. It's quite similar to an operating agreement with a LLC, but bylaws are typically a little more detailed depending on the company because they also spell out how directors are nominated, um, how they are replaced, how voting occurs, and generally how you want the corporation run. It's a living document that can be amended, but typically it's kept within the corporate records, just like a shareholders agreement. But for the most part, it is mandatory. So those are the main differences between a shareholders agreement and bylaws. There's plenty more, but for the purposes of this video, we'll keep it a little bit short. If you're not really sure exactly if you want to be a corporation and have to deal with these things, then you should definitely speak to an attorney. But if you are going to form a corporation, just know that you should have a shareholders agreement and you must have bylaws. I hope this video was informative. If you liked it, please feel free to like and subscribe. Our website is going to be in the description, and if you want to talk, to have a 15-minute business strategy session, you can book in the description as well.